Bentham's letter, Letter 4, of completeness as applied to the body of the laws, and herein of common law. To be known, an object must have existence. But not to have existence, to be a mere non-entity, in this case, my friends, is a portion, nay, by far the largest portion of that which is passed upon you for law. I speak of common law, as the phrase is, of the whole of common law. When men say to you the common law does this, the common law does that, for whatsoever there is of reality, look not beyond the two words that are thus employed. In these words you have a name, pretended to be the name of a really existing object. Look for any such existing object, look for it till doomsday, no such object will you find. Great is Diana at the Ephesians, cried the priests of the Ephesian temple, by whom Diana was passed upon the people as the name of a really existing goddess. Diana a goddess, and of that goddess the statue, if not the very person, at any rate the express image. Great is Minerva of the Athenians, cried at that same time, you need not doubt of it, the priests of the temple of Minerva at Athens, that Athens at which street Paul made known, for the first time, the unknown god. The priests of Athens had their goddess of wisdom, it was this Minerva. The lawyers of the English school have her twin sister, their goddess of reason. The law, meaning the common law, the law, says one of her chief priests, Blackstone, is the perfection of reason. Would you wish to know what a real law is? Open the statute book. In every statute you have a real law. Behold in that the really existing object, the genuine object, of which the counterfeit, and pretended counterpart, is endeavored to be put off upon you by a lawyer, as often as in any discourse of his the word common law is to be found. Common law, the name of an existing object? Oh, mischievous delusion! Oh, impudent imposture! Behold, my friends, how, by a single letter of the alphabet, you may detect it. The next time you hear a lawyer trumpeting forth his common law, call upon him to produce a common law, defy him to produce so much as any one really existing object, of which he will have the effrontery to say that that compound word of his is the name. Let him look for it till doomsday, no such object will he find. Of an individual, no, but of an aggregate, yes. Will that be his answer? Possibly, for none more plausible will he find anywhere. Plausible the first moment, what becomes of it the next? An aggregate, of what can it be but of individuals? An individual common law, no such thing, you have acknowledged, is to be found. Then where is the matter of which your aggregate is composed? No, as soon will he find a body of men without a man in it, or a wood without a tree in it, as a thing which, without having a common law in it, can with truth be styled the common law. Unfortunately, my friends, unfortunately for us and you, in the very language which we all speak, there is a peculiarity, in a peculiar degree favorable to this imposture. Not in any existing European language but ours, is the same word in use to be employed to denote the real and the factitious entity, not in the ancient Latin, nor in any of the modern languages derived from it, not in the ancient German, nor in any of the modern languages derived from it. Behold here the source of the deception. But in the mind of any man, by whom this warning has been received, no deception will it produce, unless in this instance imposture be more acceptable to him than truth. In the article A, in the single letter A, he is an ethereal spear, by the touch of it he may as often as he pleases, lay bare the imposture. A statute law, yes. A common law, no, no such thing to be found. Be it a reality, be it a mere fiction, what is but too undeniable, and too severely felt, a something all this while there is, with which you are ever and anon perplexed and plagued, under the name of common law. Yes, says our lawyer, and, allowing to you that in common law there is no such thing as a law, yet what you will not deny, and what will equally suit my purpose is that such things there are, yes, and in no small abundance such things there are as rules of law. So much for our lawyer rules. Yes, say I, rules of law? Number these rules, whom are they made by? To this question to find any positive answer is possible or not, as it may happen. But what is not only always possible, but always true is, that the person or persons by whom these rules, whatever they are made, is or are, in every instance, without exception a person or persons who, in respect of any party or they may take, or be supposed to take, in the laying down of any such rules, have not any title to make law, or to join in making law. The sort of person whose case, among those who have not a title to make law, comes nearest to the case of those who have, is a judge. But no law does any judge, as such, ever so much as pretend to make, or to bear any part in making. What, if passed, he would take upon him to say he does is, to declare law, to declare what, in the instance in question, is law, to declare that a discourse, composed of such or such a set of words, is a rule of law. Thus speaking, he would be speaking the words put into his mouth by Blackstone. Meantime, be it or be it not a rule of law, here at any rate is a rule, which having been made, must have been made by somebody. What is more, not only has it been made, but, by some judge whose duty it is to give to real laws the effect of law, the effect of a law, as if were a real law, has been given to it. The effect? And what effect? Exactly the same as if the words which it is composed of were so many words, constituting the whole or a part of some really existing law. In the words in question, the rule in question, was it then ever declared before? If not, then in truth and effect, though not in words, the judge by whom this rule is declared to be a rule of law, does, in so declaring it, and acting upon it, take upon himself to make a law, and this is the pretended law he takes upon him to make. If it was declared before, then not having been made by a legislator, it must have had for its maker some person, be he who he may, of whom thus much is known, viz. That in the matter in question no right had he to make law, for its maker, either some judge, that is, a man who does not pretend to have any right to make law, or some other man who was still further from having any such right than a judge is. At any rate, not having been made by any of one of your respective legislatures, this thing then, which, by your judges and your other lawyers, is passed off upon you as and for a rule of law, viz. Of English common law, if not by a judge, by whom, then, was it made? For laws do not make themselves any more than snares or scourges of all persons, who, on the making of it, can be supposed to have had a part. The only individual in relation to whom you can have any complete assurance of his having had a part in the making of it is a printer. The printer by whom the first printed book in which it was to be found was printed. But, though it is not without example for the man by whom a book is printed to have been himself the author of it, examples of this sort are comparatively rare. In the ordinary case, then, here you have two persons who have each of them borne a part in the making of this discourse which is palmed upon you for law, two persons, who to you, let it never be forgotten, are both foreigners. This book, then, on what ground is that the author and the printer together can have thus taken upon them to pass it off in the first place upon us, in the next place, such is your goodness, upon you as and for a book of law? First or last, the ground, at any rate the most plausible ground that can be made, comes to this: a portion of discourse, said to have been uttered by some judge, on the occasion of some decision pronounced by him in the course of a suit at law of this description, take it at the best, was, or in the book was said to have been this pretended rule of law, a pretended rule of law made, or pretended to have been made, by a functionary, who, as such, neither had, nor, as you have seen, could so much as have pretended to have, any right or title to make law, or so much as to bear any part in the making of any one law. Yet, in relation to law, be he who he may, this judge not only claimed a right to do, but has an indisputable right to do something. What is this something? Take, in the first place, to render the matter intelligible, the case of the only real sort of law, statute law, and suppose that the sort of law under which the judge is acting, what in this case is it that, in relation to this same law, he has to do? By some person, say a plaintiff, the judge has been called upon to do something at his instance, something at the charge of some other person who, if he opposes what is thus called for, becomes thereby a defendant. Why is it that I am to do this, which you are thus calling upon me to do? Says the judge. Because, says the plaintiff, a law there is, which, in the event of your being called upon by a person circumstanced as I am, has ordained that, at the charge of a person circumstanced as the defendant is, a person circumstanced as you are, shall so do. This law says so and so. Look at it here if you have need. It is a discourse which is in print, and to which, at such or such a time, by the constituted authorities, whose undisputed right it was to do so, was given the name and force of law. Hearing this, or to this effect, the judge, the facts on which the plaintiff grounds himself being regarded as proved, the judge, does he do that which by the plaintiff he is thus called upon to do? What he thereupon and thereby declares expressly, or by necessary implication, is, that the portion of law, in virtue of which the plaintiff called upon him so to do, is a portion of law made and endued with the force of law, by an authority competent so to do, and that of this discourse the true sense is the very sense which the plaintiff, on the occasion of the application so made by him, has been ascribing to it. Thus doing, what is it that, in current language, the judge is said to have been doing? Answer: pronouncing a decision, a judicial decision, in particular a judgment, or a decree. Sometimes it is called by the one name, sometimes by the other, whereupon in virtue, and in pursuance of this decision, if need be, out goes moreover in his name an order, a writ, a rule. Sometimes it is called by one of these names, sometimes by another, but if it be a rule, nothing more than a particular rule, bearing upon the individual persons and things in question, at any rate, ordering the defendant to do so and so, or ordering or empowering somebody else to do so and so, at his charge. That you may see the more clearly what is done under sham law, herein above then you have an account of what takes place under real law. Well, now, suppose statute law out of the case. What is done, then, in the name of the common law. In this case, then, observe what there is of reality, and what there is of fiction. What, in this case, supposing the matter contested really has place, is, as in the other case, a decision pronounced by a judge, say by that same judge, a decision by which expression is given to an act of his judgment, followed by an order, or what is equivalent, by which expression is given to an act of his will. The order is but particular, the decision is in the same case. But, to justify him in the pronouncing of this decision, something which men are prepared to receive as law is necessary. Real law, by the supposition there is none, fictitious law must, therefore, be feigned for the purpose. What does he then? As above, under the name of a rule of law, either he makes for the purpose a piece of law of his own, or, as above, he refers to, and adopts, and employs for his justification, a piece of law already made, or said to have been already made, by some other judge or judges. What must all this while be acknowledged is, that, setting aside the question of its propriety and utility in other respects, if, so far as regards certainty, viz., on the part of the decision, certainty, and, on the part of those persons whose lot depends on it, the faculty of being assured beforehand what it will eventually be, a decision grounded on this sham law were upon a par with a decision grounded on statute law. Thus far, at least, it would come to the same thing, and it would be a matter of indifference whether the rule acted upon were put into the state of statute law, or kept in the state of common law. In that case, for determining the utility of the proposed operation called codification, the only question might be, as between the two sorts of law, which of the two, their respective sources considered, afforded, generally speaking, the fairest promise of being most conducive to the universal interest. That which, at the present time, in contemplation of the exigencies of the present time, would have for its authors citizens of the state, mostly natives of the country, chosen by the rest of the citizens, in like manner mostly natives, or that which, in the course of several hundred years, was made at different times by from 1 to 5 persons, every one of them appointed by a monarch, under a constitution of which, even in its most improved state, the yoke was found by you to be so grievous that, at the imminent peril of your lives and fortunes, and by the actual sacrifice of them to no small extent, you resolved to shake it off, and shook it off accordingly. Thus much as to what, for illustration's sake, may be conceived to have been the case. But, alas! Look to what is really the case. The more closely you examine into it, the more clearly will you perceive that even on the ground of certainty no comparison will this sham law be able to stand with real law. Yes, as well in point of stability might you compare the waves of the ocean with the rock they beat upon, as in point of certainty statute law with common law, with this only genuine sort of law, which it is here proposed to substitute throughout to that spurious sort. Suppose, then, my friend, whoever you are, suppose that, on the strength of this or that particular decision, or this or that general rule, by the advice of a lawyer whom you have consulted, a suit at law has been engaged in by you, either in the situation of plaintiff, or in the situation of defendant. For simplicity's sake, say in that of plaintiff. If in that of defendant, the same or the corresponding observations will still apply. In appearance, suppose this decision ever so clearly decisive in your favor. Observe how many and what chances there are of its proving insufficient, and by reason of its insufficiency occasioning you to lose your cause. Observe the list of objections, observe the alleged grounds or causes of invalidation, grounds or causes more or less peremptory, through which it has to run the gauntlet of the rules in question, so improperly called rules of law. The sources are, as above, called decisions. Of these general rules, particular decisions, from preceding decisions come rules, and from these rules again succeeding decisions. Out of these rules and decisions are made treatises and abridgments. Treatises, containing with or without rules, argumentation about rules; abridgments, containing alleged rules, with or without, commonly without. The argumentation out of which the rules were spun, and in which they were drowned. The books in which are contained the decisions said to have been pronounced on each individual occasion, with the argumentation by which they are said to have been preceded, and the rules which in the course of that argumentation are supposed to have been laid down as referred to, are called report books. Behold now a sample of the objections of the alleged causes of invalidity or insufficiency, on the ground of any one of which, much more of all of them or a number of them together, the decision or supposed decision, on which the confidence of your advisers rested, may by the judge be found to be insufficient in such sort, that in consequence of the alleged insufficiency, you will lose your cause. Behold them, if your patience serves you, here below. 1. If there be but one report book in question, the reputation of the reporter not positively high in the scale of accuracy. 2. If there be two report books reporting the same cause and giving statements in any material particular different, of that which is in your favor, the reputation in the scale of accuracy not so high as of that which is against you. If, on either side, or on both sides, conflicting reports more than one, confusion and uncertainty proportionable. 3. The whole aggregate of the relevant facts not sufficiently stated. If it had been, the decision or the rule would not have been as it now appears to be in your favor. 4. The matter in dispute was not of such value as to have engaged, either on the part of the arguing counsel on the side opposite to yours, or on the part of the judge, a degree of attention sufficient to warrant the placing any such reliance on the decision or the rule, as is or can be adequate to your purpose. 5. On the side opposite to the decision or the rule, relied upon by you, the counsel was not of such known ability as to have brought out against it all the objections that might have been brought out. 6. Of the point on which the particular decision in question was grounded, the importance, with reference to the ultimate result of the cause to the parties, was not so great as to have attracted to it, on the part of the counsel as above, or the judge, a portion of attention adequate to the purpose. With reference to the principal point, this collateral point was either altogether irrelevant, or but collaterally and weakly relevant. 7. 1. In case of unanimity real or apparent, the reputation of the judges in general, or of the presiding judge, was but low, viz., either in the scale of probity or else in the scale of intellectual aptitude. 8. 2. In the particular class of cases in question, without prejudice to probity or intellectual aptitude, the state of the times was such as would naturally be productive of a too favorable prepossession in favor of the decision or rule on which you lean. 9. 3. In a case of known want of unanimity, the reputation of the judges by whose preponderant suffrages the decision on which you bear was pronounced, or the rule laid down, was not so high in the scale of reputation as that of the judge or judges who were on the opposite side. 10. 4. The opinion of the bar was in general decidedly and notoriously adverse to the decision or the rule on which you lean. 11. The printed and published decision in question, overruled by an unprinted and unpublished one, the report of which is inaccessible and even unknown to every man but the one who, happening to be possessed of it in manuscript, comes out with it, if it happens to suit his purpose, otherwise not. 12:21. In case of decisions, two or more, pronounced, or rules laid down, whether at the same time by judicatories of equal authority, or at different times by the same judicatory, some favourable to you, others adverse in this case, while the above objections are opposed to those which are in your favour, the grounds of confidence respectively opposite to these objections, may, in many of the instances, be employed in support of such decisions or rules as appear to be against you. Thus stands the matter in England, and thence in your several American United States. In any one of these states add the ulterior source of doubt and uncertainty to your prejudice, which may have place, in respect of relevancy to the state of law and society in these states in general, or in your own in particular. Thus in the case of common law, in the case of statute law, of all these sources of uncertainty and insecurity, what is the number that can have place? Not one. In the case of statute law, no law can ever come into competition with any law of posterior date. To the necessary uncertainty of common law, add now its equally necessary incorrigibility, incorrigibility as in relation to all other points of imperfection, so in a manner particular in relation to this. Imperfections in statute law, continually cured by statute law. Imperfections in common law can never be thoroughly cured by common law. By common law they cannot be cured, and by statute law it has never been the fashion to cure them. Without the concurrence of lawyers, non-lawyers in the legislature would not know how, or would be afraid to attempt to, cure them, but, to lawyers, to bestow any such concurrence is not, generally speaking, by any means pleasant. In common law, they behold, as you have seen, the goddess of their idolatry. By anything that contributes to the lessening of her glory, they have nothing to gain, they have much to lose. By common law, I say, imperfections in common law never can be cured. By every attempt made at any such cure, whether for the moment the particular mischief in question be or be not excluded, general uncertainty, a disease, with which as with a palsy, the whole frame of this fictitious body is shaken, is a sure result. If, by the judicatory in question, on the occasion in question, the authority of the decision or the rule in question can be overthrown, so by this same or any other such judicatory may any other, in this way may the authority of the whole system of common law be shaken, and with it, in so far as the contrariety is known, the confidence hitherto so generally, but always so unwarrantably, reposed in it. To save it from this reproach, recourse has been had to one or other of two expedients, viz., forced construction, or distinction. First, then, as to forced construction, upon the phrase employed in giving expression to the decision or the rule in question, the judge puts a sense of his own, such as no other man upon earth would have thought of putting upon it. But, by this remedy, the disease instead of being cured, is aggravated. The more extensive a man's acquaintance is with the language of common law, the greater the number he finds of these forced constructions, and the greater the number of them thus found, the better grounded, and naturally the stronger, is the general assurance thus obtained, that the whole of the field over which the dominion of common law has extended itself, has been thick sown by her with traps. Thus much as to forced construction. Now as to distinction, taking a distinction as the phrase is, in a statute law on the occasion of every rule laid down, a sort of caution, which by the penman is observed of course, is, to ask himself whether his purpose requires that the rule should be conformed to throughout the whole of the extent which the words of it import, or whether, to give a correct expression to his meaning, there may not be this or that exception, that requires to be taken out of it, and if yes, set down of course is the description of all such particular exceptions in the train of the general rule. This being the case, one good consequence is, that whatsoever notification is given to the general rule, is given, and at the same time, to all the several exceptions, by which its extent is limited, and its import fixed. Such being in this respect the case under statute law, observe now how it is under common law. Open a book of common law, be it report book, be it abridgment, be it treatise, among rules by dozens and by scores, scarcely will you find one, but what, if it be not itself an exception to another, or even if it is, has exceptions tacked to it. But those exceptions, at what time was it that they were respectively tacked to it? At the time of laying down the general rule? No. But each of them at a different time, on the occasion of this or that one decision was the general rule laid down, on the occasion of so many different decisions, pronounced each of them at a different point of time, these several particular rules. When an exception of this sort is applied to, or rather taken out of a rule, thus it is that a distinction is said to be taken. But, to the possible number of these distinctions never can there be any adequate assurance of an end. What is the consequence? That in the whole body of rules, such as they are, of which this common law is composed, seldom can you find one which is not pregnant with deceit and disappointment. Say, that here or there, this or that one there may be, to which at no time any exception, or, if exceptions have been attached to it already, any ulterior exception, would ever be attached. But whatsoever just ground for confidence to be reposed on might be framed by these few trustworthy ones, is destroyed by the multitude of untrustworthy ones, with which they are encompassed and confounded. I say, confounded, for to the trustworthy ones no earmark is there, whereby they can be distinguished from the untrustworthy ones. To apply this general matter to your own particular case, my friend, as above supposed, first, see how you may be disappointed and ruined, by means of a forced construction. The decision or the rule upon which, as above, your leaning was, is, as it stands, clearly in your favor. But, authorized by a practice so extensively pursued and so familiar to everybody, the judge, to compass his object, whatever it may be, has recourse to the expedient of a forced construction. He puts a new, and till then never imagined, sense upon the words, either of this very decision or this very rule in which your trust was, or of some other, which, by this means, is set in opposition to it, and enables him to destroy the effect of it. Next, observe how you may be put into the same sad case, by means of a distinction, taken in its generality, taken in the whole of its extent, with the exception of one particular part. The judge sees nothing to object to in the particular decision or the general rule on which you rely. But upon a close view of it, he sees reason to take a distinction, that is, to take out of the general rule a particular case, to which it seems to him that it ought not to be considered as extending, which particular case is exactly the case in which you stand. Such might be the uncertainty of the law, such the insecurity of the citizen under it, even if the whole mass of the matter of which it is composed, of the matter in which these rules are contained, or out of which they are deduced, were at all times in the hands of everybody. But in this respect, how stands the fact? In your country more especially, neither the complete stock of data, nor anything approaching to it, is in the hands of anybody. Volumes, by scores, by hundreds, not to say by thousands, dollars, by thousands, not to say by 10,000s, would be necessary to complete it. In a word, a complete law library would be necessary, nothing less. Whether, even in this country, in which this immense mass of delusive learning has its source, in any one hand any such collection is to be found, is more than I would undertake to say. What I would undertake to say, and without much fear of contradiction, is, that in no one hand would any one such thing be to be found in all your United States, on the day on which these letters are landed. If even, in each of your United States, not one only but half a dozen hands, each of them possessed of such a treasure were to be found, what would the citizens at large be the better for it? The result would be a monopoly of this necessary of life, a monopoly, with this half dozen of monopolists sharing in it. Suppose even, that in the day, for example, on which this letter of mine is landed, a large library thus complete were in the house of every lawyer in all your United States. Even in this miraculous case, what would any one of those your lawyers, not to speak of the rest of you, be the better for it? By the next arrival comes a cargo of fresh English-made law, by which to an indefinite extent the anterior stock of law is superseded, some of the general rules completely overturned and superseded by rules of equal extent, or by rules of greater extent in which they are included, others, cut into and superseded in part, by distinctions and exceptions. Even if it came from a legitimate source, from hands competent to make law, thus incapable of being known, even to your lawyers? Would this English common law be, thus incapable are they of knowing it, they, whose profession it is to know it, and who, on pretence of knowing it, take payment of you for communicating to you what they thus pretend to know? But, if such is the case with those who pretend, and are thence supposed to know it, what, my friends, must your case be, you who, knowing but too well that you neither do know it, nor of yourselves are capable of knowing it, have no other means of keeping yourselves safe from the perils with which you are encompassed by it, than by repairing, on the occasion of each question, to one of these, your living oracles, and asking him what it is he knows or thinks about it? Great as it is, the perpetual state of insecurity in which you are all kept by this imposture is not the only mischief produced by it. From the uncertainty comes not only insecurity, but corruption. Insecurity in the situation of the non-lawyer, corruption, or at least a most powerful and perpetual temptation to it, in the situation of the lawyer, and in particular in that of the judge. In most of the instances in which, under common law, a case has been seriously argued, the judge might, without reproach to his probity or his judgment, have pronounced a decision opposite to that actually pronounced by him. In the character of a well-considered maxim, the fruit of long meditation, operating upon long experience, from how many mouths, without communication with one another, has it not happened to meet or hear an observation to this effect? No such conception at the same time appearing to have been entertained by the author as that, by this observation, any sort of reproach was cast upon this spurious sort of law, or upon any man from whom it ever received support or eulogy. No cause ought ever to be given up as desperate. First, from the mouth of Wedderburn, and in these very words, was the aphorism brought to me, presently after it was uttered. Wedderburn was at that very time in office, soon afterwards, under the title of Lord Loughborough, surmounted afterwards by that of Earl of Roslin, Lord High Chancellor of England, head of English law. In your country, not to speak of this, the power which is thus in every instance arbitrarily, is it ever in any instance corruptly exercised? This, it is not for me to say, for it is not possible for me to know. This, however, I will take upon me to say, that for corruption, supposing at any time a man disposed to give himself to it, the head of man could not conceive, nor the heart of man desire, a more efficient cloak, and that under it whatsoever corruption has not place, it is to the individual, not to the state of the law in this respect, or, if to the state of the law, not to the state of this part of the law, that all thanks are due. True it is that under the worst system of judicature imaginable some points there would always be, too clear to admit of wrong decision without infamy. But, in regard to the bulk of those which, in the present state of judicature, whether among us or among you, come actually under debate, if being a judge, my object were to gratify under favour, prejudice, antipathy, even lust of gain, so it were without need of communication between myself and the party, no difficulty could I find, and if, being in possession of supreme power, it were my desire that judges should have the faculty of acting corruptly for ever in their hands, no means so effectual could I find as that of ordaining that, throughout the whole field of law, the rule of action should be and continue everywhere in the state of common law, nowhere in the state of statute law. For my own part, considering the nature of man on the one hand and the state of the law on the other, I do not see how it is possible that corruption of this necessarily unpunishable kind, should not, in every country, to the extent of the dominion exercised by common law, be in no inconsiderable degree frequent. To any judge not known to me, to any judge individually taken, nothing of corruptness can I impute, in my own mind, on the score of his acting under the system in question, thus favourable to corruption as it is. But not altogether easy would it be for me, in my own thoughts, to exempt from the imputation of corruption the mind of a judge who, with this picture before his eyes, this picture of the invitation given by the system to corruption, should persevere in any such endeavour as that of putting an exclusion upon any measure which, without being pregnant with mischief in any assignable shape, should afford a promise of making any sort of advance towards the ridding the community, be it what it may, of so pestilential a nuisance. After all, when corruption, on the part of the judge, is spoken of as a thing distinct from uncertainty on the part of the law, only to the cause, or perhaps to the quantity of the effect, does the distinction apply, not to the nature of the effect. For argument's sake, suppose every judge, without exception, were corrupt, wherein would ultimately consist the real mischief? Wherein, but in this, viz., that no man could possess any tolerably firm assurance, but that, by means of this corruption, he remained continually exposed to injury, in every shape and without redress. Well, though in degree, it be extreme in specie, all this is but uncertainty of the law, and nothing more. Away with exaggeration, away with indiscriminating antipathy. A scourge as it is now, this sham law, time was when it was a blessing, nay, in a certain point of view it will be seen to be a blessing even now. You have seen what it is made of, and how it has been made, viz., from particular decisions, general rules deduced by judges and others, by the authors or by others. Those rules, before printing was in use, accidentally committed to writing, after that to printing, and thus made public, every tittle of it made by individuals, not one of whom so much as pretended to have any such right as that of making law. But, in those same days, improper as was the language, by which any such name as law was given to them, these rules, such as they were by no means without their use. Decisions and rules together, they formed, not only a light, by which the paths taken by succeeding judges were lightened, but a barrier, by which they were in some degree kept from going astray. In the character of a barrier, the effect they produced was in some sort, however imperfectly, the effect produced by real law, in the character of a light, howsoever faint, and frequently false, they produce another good effect, and that of a sort very scantily and irregularly, if at all, produced by real law. Ever and anon, by reasons such as they were, and not always bad ones, a ground was made for these rules, and, along with the rest of the matter, these reasons were made public, and that at a time when little or nothing in the shape of reasons was visible in the character of an accompaniment to any portion of real law. Antecedently to the appearance of these lights, what was the state of the rule of action, and of the citizen under it? Every decision was completely arbitrary, every judge had to begin afresh, no improvement in judicature, no art, no science, because no experience, no materials out of which grounds for real law could be made. With the decisions were necessarily recorded the cases by which decision was called for example, the sorts of offences capable of being committed, the sorts of contracts capable of being entered into, the sorts of incidents, by which, to one or other of the parties, or to the public at large, the contract was capable of being rendered unexpectedly injurious, the sorts of titles, by which a reasonable claim to property was capable of being produced or put an end to. A library, composed of the books in which these cases are thus brought to view, such a library, even though there were not so much as a single law in it, is at any rate a rich storehouse of materials for legislation, such a storehouse, that without it no tolerably adequate system of laws could be made. The more ample the stock, so it be not to such a degree vast that the mind is lost in it, the more effectual the provision made for this most necessary and arduous of all intellectual works. The greatest quantity of wealth, possessed in this shape by any other nation, penury in comparison of that which has been furnished by English common law. In this point of view, it is a blessing even now. As a light to the legislator, to assist him in the making of real law, it is a matchless blessing, this sham law, as a substitute to real law, now that the times are ripe for the making of real law, in this character, indeed, though in this character only, is it a curse. Time was when, for want of recorded experience, the pen of the legislator could find no tolerably adequate indications for its guidance. Time was, but that time is now, at least, at an end. Yes, in comparison of the practice of deciding each individual case purely on its own ground, without regard to consistency in relation to former decisions, and without looking for guidance to any lights derivable from former ones, the practice of resorting to memorandums, made of the purport of former decisions, and of the circumstances in which they were pronounced, was, doubtless, notwithstanding the looseness and untrustworthiness so frequently exemplified in those memorandums, a vast improvement. But, On no grounds can the advantageousness of this practice be demonstrated, but on those same grounds the superior advantageousness of the form of real law, in comparison of the conjectural and fictitious substitute, framed by imagination out of those same materials, will be rendered 10 times more strongly and clearly visible. Every man his own lawyer. Behold in this the point to aim at. Why every man his own lawyer? 1. Because no man's interest is as dear to his lawyer as it is to himself. 2. It is not every man that can afford to pay a lawyer. 3. No man, how rich soever, can have a lawyer always at his elbow. Every man his own lawyer? Yes, but who shall make him so? Not he himself, as would be the case if, instead of lawyer, you were to say tailor, shoemaker, or, as may be seen in the title of a book, broker. One sort of person there is, by whom, so far as the nature of things allows, every man may, and by whom alone any man can, be made his own lawyer, and that is the legislator. I say so far as the nature of things allows, for, the legislator has done his utmost. Still, the possibility of a man's being his own lawyer will depend on the nature and situation of the man. As to more or less of the law, to some will always be wanting the necessary talents, to anyone may at any time be wanting the necessary time. No business can be mentioned, in which it may not incidentally be more for a man's advantage to carry it on by proxy than to carry it on himself. To so universal a rule assuredly no exception can be afforded by law business. No, never can the profession of a lawyer be wholly superseded, never, at any rate, the office of a judge. But, in the impossibility of attaining the summit of perfection, no reason can be given for not aiming at it. By every step made towards it by the legislator a blessing is bestowed. Take in its utmost extent the mass of legislative matter with which, in the country in question, the universal interest requires that the field of law shall be covered. Take any portion of it whatsoever. What is necessary is that such part as the pen of the draftsman finds in the state of common law, and such part as it finds in the state of statute law, should, without any distinction, be cast together in one mass. What part he finds in the one state, what part he finds in the other, what part of the field, finding it as yet unoccupied by both, he sees reason to cover with new matter, in no instance need any trace of distinction be exhibited, none, at least, in respect of the form given to the matter. Howsoever, in the way of note, intimation may be conveyed of the distinctions which once had place. Accidental as these distinctions are, the boundaries shifting place from day to day, no use can there be in keeping them on foot. All this while, let it never be out of mind, that in no case, by any part of the authorized rule of action, can any good effect be produced, any further than as it is known. To no part of it is it possible to be made known, any further than it has been made complete.